dissolution, meaning they should do, sign altogether, meaning they agree, divorce, they don't have any children, they don't have any spousal support. In case, if they want, they can sign on the paper, they can do that. Dissolution. On the top, attorney or party without attorney, the same thing. Superior Court of California, County of Los Angeles, same thing. Marriage of partnership of petitioner one, doesn't matter who's husband or wife, petitioner one. Petitioner two, the other party. Joint petition for summary dissolution, marriage. If they don't have any marriage, domestic partnership. We petition for a summary dissolution of a marriage, registered domestic partnership, or both, and declare that all the following petition exists on the date this petition is filed with the court. Number one, we have read and understand the summary dissolution information booklet form. 2, A, we were married on some date. B, we registered on domestic partners on date. Just 2, A, we can do it. 3, we separate on today or someday. We separate. Number 4, leave down 5 years have passed between the date of our marriage. Less than 5 years have passed between the date of our marriage and or registered of the domestic partnership and the date of our separation. Number 5, one of us has lived in California. Page 38. One of us have lived in California for at least 6 months and in the county. If we get in for the divorce in California, we have lived 6 months, at least 6 months live in California, and then also in the county of living at least 3 months. 6 months live in California, at least 3 months live in this county. Proceeding the date of filing, or we are only asking to end a domestic partnership registered in California. B. We are the same sex and were married in California but are not registered a resident of California. Neither of us impels that will allow us the divorce. We were filing this case in the county in which we married. Same sex in case, same thing. Number 6. There are no minor children who were born of our relationship before or during our marriage or domestic partnership or adopted by will allow us to divorce. We were filing this case in the county in which we married. 6, 7, 8. Everybody is same thing. 6. There are 2 minor children, no minor children, who were born of our relationship before or during our marriage or domestic partnership. Domestic partnership or adopted by us during our marriage. No children meaning they don't have any, no adopt either. If they have a marriage period, if they have adopt, they cannot. Neither of us, to our knowledge, is pregnant. Right now, currently, if somebody they have pregnant, they cannot. Number 7. Neither of us has an interest in any real property. Number 7. Neither of us has an interest in any real property anywhere. You may have a lease for a residence in which one of your lives. It must terminate within a year from the date of filing this petition. In divorce case in California, both agree in 5 years less. Eight, except for obligation with respect to cars on obligation incurred by either or both of us during our marriage or domestic partnership. we owe no more than $6,000. Six, the total fair market value of a community property asset, not including what we owe on those assets, and not including cars is less than $41,000. Page 38. Page 38, number 9, number 10. Neither of us has a separate property asset, not including what we owe on those assets and not including cars in excess of $41,000. 11. We each have filed out and given the other of income and expense declaration. 12. We have complied with the preliminary disclosure requirement as follows. 12. Number 12. We have complied with the preliminary disclosure requirement as follows. A. We each have disclosed information about the value and the division of our property by filing out and giving each other copies of the document linked in 1 or 2 below. 1. The worksheet on pages 7 and 8 and 11 of the summary dissolution information booklet. Number 2. A declaration of disclosure, a petition of the asset and the debt, or a property declaration,
Big statement.
and all attachment to those forms. B. We have told each other in writing about an investigation between or other income, production, opportunity, and cable. After we were separated based on investigating investments made or worked done during the marriage or domestic partnership and before our separation. Number 3. We have a declaration. We have exchanged all tax returns. Each of us has filed within the 2 years before disclosing the information described in 12A. Next page, number 39. 13. Check whichever statement is true. Number 8. We have no community asset or liability. B. We have signed an agreement listing and dividing all our community assets and the liability, and have signed all the papers necessary to carry out our agreement. A copy of our agreement in attachment to the judgment of declaration of dissolution and notice of entry of judgment. '14. Irreconcilable difference have caused the intermediate breakdown of our marriage. Any cases they wanna divorce, the main reason, just one, irreconcilable difference of our marriage and or domestic partnership. And each of us wishes to have a court dissolve our marriage and of the domestic partnership without our appearance before a judge. 15. A petitioner one desire to have his or her former name restored. The name is basic. Before the marriage, my name is something, and then I should go back. The petitioner two desire to have his or her former name restored. Their name is somebody. 16. We each give up our right to appeal and to move for a new trial after the effective date of our judgment or dissolution. We have agreed to keep the court and each other information of any change of mailing address or phone number occurring within 6 months from the filing of this joint petition, using the notice of change of address of our contact information. 19. We are submit the original and 3 copies of the proposed judgment of dissolution and the notice of entry of judgment, and 2 stamped envelopes together with this petition. 1 envelope is addressed to petitioner 1 and the other to petitioner 2. 20. We agree that the matter may be determined by a commissioner sitting as a temporary judge. 21. Mailing address of petitioner 1. 22. Mailing address of petitioner 2. Some address. 23rd, number of page attached, somebody, something. I declare under penalty of perjury, under the laws of the state of California, that the foregoing and all attached documents are true and correct. Today's date, sign. Right sign the same thing. The other party. I declare under penalty of perjury, under the laws of the state of California, that the foregoing and all attached documents are true and correct. Sign. Both parties should sign. Dissolution of marriage processing. First, file the petition. And delivery to the other party. Three, file for the proof of service. Proof of service, I delivery to the other party. That's meaning proof of service. Number 4, after that, if the other party not filing the answer, number 5,
or 7.
8
petitioner
and review.
No.
should file
Why?
request for request for default. Okay, please watching. This is the regular dissolution of marriage, but we do summary dissolution of marriage. Both parties should sign under the paper, and then they file for the court. In case, what's the difference? Regular dissolution of marriage, this one, but summary dissolution of marriage, they file a petition. Both parties. Sign the paper. Both parties sign the paper. And then after that, what's the difference? Which one is not filing? Which one we should not? We don't need it.
Can we answer?
Uh-huh. For, this is a regular dissolution of marriage. This one is not the regular. Summary dissolution of marriage. In case we file for the petition, after that, we need not any action. Which one we need not? Both parties sign under the paper. And then delivery to the other party. We need or we need not. We sign under the paper, both parties. and then the delivery to the other party. Delivery, we should do delivery or not?
Delivery.
Delivery should do.
Mm-hmm.
Why? Both parties sign onto the paper. And then this one party file onto the paper, the quote. This one is both party file for the quote. We don't need a delivery to the other party or not.
No.
No, we don't need it. We don't need it. And then after that, we need not deliver it to the paper party. And after that, file for the proof of service. We need not or we need.
Fine.
We didn't deliver it. And then after that, file for the proof of service. We need or not.
Yeah.
Should do.
Yeah.
Didn't deliver it. And why we need a proof of service?
No need.
We need not file a proof of service. Because why? We didn't deliver it. Problem is both parties sign on the paper and then they getting for the copy, one of each. After that, they don't need it. And then if the other party not filing the answer, they will file or they not gonna file or they should file after that. You don't know? If the other party, you can do it, I don't know. If not filing the answer, if they gonna file answer or not. Same thing, they not gonna file answer. Okay? If they not gonna file answer, should file request for default. We should do request and the default. We should do or not. If they don't have any file, we request for default. We need or not.
No more.
Uh-huh.
No need.
Need it?
No need.
No. Need not. Meaning, how simple. This one is file for the petition, delivery to other party, file for the proof of service file. If the other party not filing the answer, we should file register for default. But summary dissolution of marriage. In case summary dissolution of marriage, we need not all this case answer. We need not all just to file the petition. In case simple or not. So simple, right?
Yeah.
Yeah, so simple. On the 5-year less marriage period, they agree all together. They don't have any other action, spousal support or something. It's so simple. They don't need it. And then this one just make file, both party file. After that, next page, they do request for judgment of dissolution of marriage, and notice of entry judgment. Just this one only. Another one, they don't need it. They don't need another one. they need a file, petition file. After that, they request for judgment. So simple, so simple. If not, dissolution of marriage is difficult, different, but summary dissolution of marriage, so simple. Why? They don't need a spousal support, they don't need a child support, they don't have any child. So simple. In case, simple form, simple case, you should do. And meaning, if you want a dissolution of a marriage, as possible, 5 years less, before you don't make any children. In case, so simple. Okay, page 40. On the top, same thing. Marriage of husband somebody, wife to somebody. Title is Request for Judgment. Judgment of dissolution of marriage and notice entry of default. Notice of entry of judgment. Just one page, everything. Number one, the joint petition for summary dissolution was filed on some date. What means? Use this form only if the joint petition for summary dissolution, Form F800, was filed before January 1st, 2011. If was filed after January 1st, 2011, use judgment of dissolution of notice of entry of judgment, something. Number two, no notice of revocation has been filed and the parties have not become reconciled. Number three, I request that judgment of dissolution of a marriage be entered to the effective now. B, entered to be effective non-proton as a for the following reason. If they want dissolution of marriage, reason is just one, irreconcilable dissolution, irreconcilable. That's one, we need it. I declare under penalty of perjury, under the laws of the state of California, that the foregoing is true and correct. Date, type or print name, somebody, husband or wife. Next, for husband or wife, the other party, who did not request that he or her own former name be restored when he or she signed this petition, now request that be restored. The applicant former name is something. Judgment of dissolution. This is judgment. So simple. The court order, number 5, judgment of dissolution of marriage will be entered and the party are restored to the status unmarried person. A. Judgment of dissolution of marriage will be entered non-proton as all. B. Wife's former name is restored. C. Husband's former name is restored. Husband and wife must comply with the agreement attached to the petition. If they have any agreement, they make them. Right side. Notice of entry of judgment. We are notified that a judgment of dissolution of marriage was entered some date. Some clerk's certificate of marriage. I certify that I'm not a party to this cause, and that a true copy of the notice of entry of judgment was made first class, postage, food prepared, and sealed and addressed as shown as below, and that the notice of mail, place, date, and then signature by clerk, and then husband's address, wife's address. They divorced, they getting new address, husband address, wife's address. If they put right here, or the document is delivery. That's it. So simple. Divorce is so simple. Family law is finished. Next to page 42 is I-130, petition for alien relative to apply for the green card. From 42, family law is finished. Immigration, this one is immigration. Okay, 10-minute break, go to restroom or sleep. Okay, page 42. 42 is immigration. I-130, petition for alien relative. If you file for any immigration form, this is the first form, I-130. A relationship, you are the petitioner. Filing person is petitioner. Your relative is the beneficiary, meaning if somebody has the citizenship, then they have a petitioner, and then the other party, they don't have any green card, and they may come for the applying for the immigration in case that person is beneficiary. Number one, I am filing this petition for my spouse or parent or brother or sister or child, normally spouse. If your husband is relative, petition applying for the easy. If in case normally if they have relative citizen, in case so easy. If not a citizen, in case that's not easy, second degree. Number two, I related by adoption. If somebody wants some citizenship for adoption, in case, are you related by adoption? No. Or yes. If adoption, they cannot petition to other party, other persons. Did the gain permanent residence through adoption? Did you gain permanent residence through adoption? No. If through the adoption, yes, they can do it. B. Information about you. Name, family name. For example, Lee, first name, Howard, middle name, H or somebody. Address, number and street, apartment number, town or city, state of California. Place of birth. Number 3, place of birth, town or city, state, county, state, country, date of birth, gender, male or female, marital status, married or single. Number 7, other name used, including maiden name. Number 8, date and place of present marriage, if married. Number 9, U.S. Social Security number, if I have. 10, alien registration number. Number 11, name, prior spouse. 12, date marriage and. 13, if you are a U.S. citizen, complete the following. My citizenship was acquired through birth in the U.S., naturalization, give a certificate number and date and place of issuance. Parents, have you obtained a certificate of citizenship in your own name? Yes. Give a certificate number, date and place of issuance. No. 14. If you are lawful permanent residence alien, complete the following. The date of birth of admission for an adjustment of lawful permanent residence and class of admission. 14. B. Did you gain permanent residence state through marriage in a U.S. citizen or lawful permanent residence? Yes or no. Right side. C. Information about your relative. Name, meaning B is petitioner. He already getting the citizen. C. Applying for the registration. Name, family name, and something. First name, middle name. Address, name and street. Town, state, county, zip, postal code. 3. Place of birth. Place of birth. For example, Korea, China, or Japan. State, country. Date of birth. Gender, male or female. Marital status, married, single, widow, divorced. 7. Other name used, including maiden names. Number 8. Date and place. Present marriage. Number 9. U.S. Social Security number, if any. They don't have any, just none. Alien registration number. Name of prior spouse. Prior spouse. If you are divorced, prior spouse. Date marriage end, just a divorce date. 13. Has your relative ever been in the U.S.? Yes or no? 14. If your relative currently in the U.S. complete the following, he or she arrived as arrived departure recorded I-94. I-94 is very important. If you come to the U.S. first day, come to U.S. LA airport or other airport, they have just one paper, passport, just one paper. If somebody think, that's not important, as a throw it away. If throw it away, they don't apply for the petition. That's so important. I-94, you check it out, your passport, one paper you have it. What date you arrived at the airport or something. That's so important. Don't throw it away. Keep so important. I-94. That's live departure recording the date of life. Date of life stay expired or will expire as shown as Form I-94 or I-95. 15. Name and address of present employer. Date his employment began. 16. Has your relative ever been on the immigration proceeding? Yes or no? Where? When? Something like that. Right side, number 43, page 43. Information about your relative. List spouse and all children of your relative. If you have children, right here. 2 or 3, 4, doesn't matter. Mother applying for the green card, children is automatically they getting. Children under 18 is automatic, they can get them. 18, address in the United States where your relative intend to live. Some address, town, city, state. 19, your relative address of road include street, city, province, and country. And phone number. Number 20, if your relative native alphabet is other than Roman letters, write his or her name and foreign address in the native alphabet. Number 20, should put right down this, not the English, your country word, Japanese, Chinese, or Korean, your name, your word. Relative native alphabet is other than Roman letters. 21, if filing for your spouse, give last address at which you live together. If filing for your spouse, give last address at which you live together, including street, city, province, if any, and county. Not county, country, from to something. 22, complete the information below of your relative is in the United States and will apply for adjustment of status. Your relative is in the United States and will apply for adjustment of status to a lawful permanent residence in the USCIS. USCIS meaning Immigration Department, USCIS office in. If your relative is not eligible for adjustment of status, he or she will apply for visa allowed in the United American consular post is city, state, city, country. Designation of U.S. embassy or consulate outside in the county of your relative last registration does not guarantee acceptable for processing by the post. Acceptance is at the description of the designated embassy or consulate. Other information. If separate petitions are also being submitted for other relative, give a name of which and the relationship. 2, have you ever before filed a petition for this or any other alien, yes or no? If yes, give name, place and date of filing and the permit are reserved. Warning, USCIS, investigate claim relationship and verifies validity of document USCIS 6 criminal professions prosecution when family relationships are forced by to other visas, obtain visas, penalties. By law, you may be imprisoned for not more than 5 years or fined $250,000 or both, and enter into a marriage contract for the purpose of ending evading the provision of the immigration laws. In the addition, you may be into $10,000 and imprisoned for up to 5 years or both for knowing and willfully forced by or counseling a marriage fact or using any false document in submitting this petition. Your certification. I certify under penalty of perjury under the laws of United States of America that the foregoing is true and correct. Furthermore, I authorize the release of other information from my record that U.S. citizens and immigration service need to determine eligibility for the benefit that I am seeking. Signature petition, date, phone number. Signature petition relating this form, if other than the petitioner, I declare and prepare this document at the request person above that is based on all the information of which I have any knowledge, print name, signature, date, address, something. E is petition, citizenship. F, beneficiary. Beneficiary is the sign in the paper. Next one, 43 is I-130, that's showing person. First one is the immigration applying petition. But next page is form I-485. Same date they should file. I-130 and I-485. Same date they should file. I-130 meaning petition. Form I-485 meaning application for registered permanent residence or adjustment status, meaning applying for the green card. Same date we should file I-130 and I-485. Type of print. Part 1, information about you. Family name, last name, same thing, given name, middle name. This is the citizen, address, city, date of birth, county of birth, no, country of birth, country of citizenship, nationality, U.S. Social Security, or number, date of last arrival, I-94 arrival departure record number, current USCIS status, citizenship, expire on something. I-94, so in person, if you check it out for the passport, one paper, one paper is that is I-94. That's so important that we cannot make new one. That's so important. Part 2, application type. I am applying for an adjustment to permanent resident status because A, on immigration party petition given me an immediately available immigrant visa number that has been approved. Attach a copy of the approval notice or relative special immigration, juvenile, or special immigrant military visa application filed with this application that will give you immigrant available visa number if approved. B, my spouse or parents applied for adjustment of status or was granted lawful permanently resident in an immigrant visa category that allows deliberative status for spouse and children. C, I entered as a K-1 finance of a U.S. citizen whom I married within 90 days of entry, or I am the K-2 children or such finance. Attach a copy of the finance petition proof notice and the marriage certificate. D, I was granted asylum or deliberate asylum status as a spouse or child of a petition granted asylum and then eligible for adjustment. No. E, I am native or citizen or Cuba admit or parole in the United States as January. I am a native citizen of Cuba. If not, no. F, I am the husband, wife, or minor unmarried child of a Cuban described, it doesn't matter, not passed. E, I have a continuous residence of the United States since before January 1st, 1972. H, other base of eligibility explained. For example, I was admitted as a refugee. My status has been terminated and I have been physically present in the United States for 1 year after admission. In addition, space is needed. See page 3 of the instruction. I am already a permanent resident and an employee to have the date I was granted permanent residence adjusted to the date I originally arrived in the United States, and non-immigrant or parole, or as May 2, 1964, whichever date is later, and J, I'm a native citizen. Native citizen meaning I was born in the United States. Cuba meets the description in the above. No. J, I'm a husband, wife, or minor unmarried child of Cuba, and make the description above. Also. No. Number 3, preceding information: city, town, village of birth, current occupation, your mother's first name, your father's first name. Provide your name exactly as it appears on your Form I-94, arrival date, departure, record number, place of last entry into the United States. In what status did you last enter? Visitor, student, exchange, visitors, crewman, temporary worker without inspection. Act. Were you inspected by U.S. immigration officer? Yes or no? Non-immigrant visa number. Consulate where visa was issued. Date was issued. Number. Gender, male or female. Marriage status, married, single, something. Have you ever applied for permanent residence? State in the U.S. If yes, give the date and prior, place of filing and the final disposition. B. List of your parents, present spouse, and all of your children, including adult son and adult daughter. If you have non-additional space, page 3 of the instruction. Family name, last name, given name, first name, middle initial, date of birth, county of birth, relationship, A number meaning immigration number. Applying with you, no. Family name, second person, given name, middle name, something. County of birth, relationship, A number. Family name, the third person, last name, something. Given name, something like that. County of birth. Next one is a fourth person. If they have it, if you don't have it, you don't need it. Fill it. Family name and something. This section, even child over 18 years old, they should put right here. Just applying for the immigration under 18 only, but this section is not involved for the immigration or not. Just to, for all family, put right here. Okay. Here. You can go home.
Yes, sir.
Okay.